right.
Good morning, Your Honors. Attorney Connie Hightower, representing the appellant Anthony Brooks, who is the defendant in the underlying trial court matter. As the court is aware, this case is based on a suppression hearing, and it's based on Fourth Amendment rights against illegal search and seizure, namely as it pertains to the traffic stop, as well as to the dog sniff and the subsequent search of the vehicle. Originally, when the suppression motion in this case was filed on November 3rd, 2015, the defendant also had raised whether there was an illegal search of the defendant, but that was waived at the hearing. So it's just the car that we were concerned with in the dog sniff. The facts of the case were that basically on July 16th, 2015, Anthony Brooks was stopped by Cuyahoga Falls Police Department over near Howe Avenue and Home Avenue, coming out of the Sheetz gas station. The facts of the case in the officer's testimony, who was the only person who testified at the suppression hearing, was that Mr. Brooks was in the parking lot of Sheetz. The officer testified that he had noticed an inoperable headlight at the time. They didn't do anything about it. Brooks had pulled from the Sheetz gas station into the left-hand turn lane on Home Avenue to turn left on Howe Avenue. And it was that point in time that the officer decided that he was going to stop the vehicle. During his testimony, he had indicated that his stop was based on the illegal left turn, and it just basically loosely said Cuyahoga Falls Ordinance. We did include in our brief copies of the Cuyahoga Falls Ordinance where if it were under 100 feet or a certain amount of distance, then you want to turn into the lane that's directly going to go with the flow of traffic, turning left. And so one of the arguments, of course, is that he actually had not violated any traffic stop. Some of the facts of the case are also that the officer did say he recognized Brooks to be someone who was known to, I believe it was known to either known drug dealer or a known criminal, something to that effect. And he testified that he did know that he was black, although he didn't know his identity at the time. So some of the facts that are the crux of the case is that when the officer finally did pull over Brooks, he pulled over right away. He was looking straight ahead. He was just answering the questions of the officer. Prior to the officer approaching the vehicle, he did an internet search to see if there were any crimes that weren't coming up in his database that maybe Brooks had committed. Wasn't able to find anything on that. Then when he approached the vehicle, he asked Brooks a series of questions, all of which had nothing to do with a headlight that wasn't working or had anything to do with a turn.
Could I stop you?
Yes.
Because when I was reading that, I was like, an internet search.
Yes. I think he said web search might have been his exact phrase, but apparently he went online and searched and Googled. I don't know what he Googled, but Googled loosely.
Is that all the evidence was presented, was just that? I mean, nothing further?
As far as
Well,
the internet search?
Yeah, what that comprised, I mean, because I've just never heard of a police officer at the scene going online to find things.
I haven't either. I believe he said he ran it through Leeds, which
Right.
is normal, and he didn't find anything, and then he ran it through, he did say that he found that there was a suspension that was done due to a drug offense back in 2006 or something like that. But other than that, no, the testimony, and I wasn't the trial court attorney, but the testimony and review of the transcripts just shows that he said he then, after not finding anything on Leeds, conducted a web search to see if he could find anything else out about the defendant.
Facebook?
I don't know.
That's exactly
That's
what
the
I'm
thing.
thinking.
It could be, I'm assuming, and maybe I shouldn't, but it was probably Facebook, some sort of Google search, maybe Bing or Yahoo or some sort of search engine. But it also seemed that either from his search or from Leeds, he was able to find that 2006 suspension, driver's license suspension, but that was it. So all the while that this web search is occurring, the defendant is still seated in the car and the officer has not approached the vehicle. Once the officer approaches the vehicle, then he did ask Brooks a pertinent question, which is, where were you coming from? And he explained he was coming from Amigos and was going home. The questions that came after that were questions about, have you ever been arrested? Whether are you on a probation violation, or are you on any sort of papers from a court? Do you have any pending court cases? He asked him whether or not him or his friends had smoked weed in the vehicle. And all of this was because of allegedly what was a headlight or an One of the reasons why we say that it was a precursory stop is not only did he notice that the defendant was black, and the officer said that he knew who the defendant was, but didn't know who the defendant was, that he was known to him, but didn't know specifically who he was. This series of questions and searching on the web search seems to be reasons to predicate looking further or being able to do the dog sniff.
But the photograph that was attached to somebody's brief that showed 15
Yes,
and all the things on the vents. I mean,
yes, the air fresheners.
Lots and lots of air fresheners in that car.
Yes, and Your Honor, I actually did itemize the reasons that the officer had said. One of those was the air fresheners, and the officer believed it was an attempt to cover up the smell of drugs, which, I don't know why there would be that many air fresheners, but there, certainly I had a high school and a college football player athlete, and, sometimes you put a lot of air fresheners in cars for whatever reason. But air fresheners was one of them. Another reason why he was suspicious, because he said the defendant was staring straight ahead when he was answering his questions. That was the second reason. And the third reason was that that the officer had asked the defendant whether or not he had any criminal record, as to which he said no, when he actually had the OVI suspension or driving under suspension. There was whatever that was in 2006 that he had. So the arguments that we bring up today is whether or not there was probable cause to search the vehicle with the dog sniff, and that's of course understated in Rodriguez. And the other is whether or not there was a reasonable articulable suspicion to stop the car at that point. Our arguments as outlined in our brief is that both of these were violative of the Fourth Amendment. I'm going to focus first on State v. Anderson, which says random stops of motor vehicles are violative of the Fourth Amendment protection unless there is at least a reasonable articulable suspicion that the motorist is unlicensed, or the automobile is not registered, or that the vehicle or occupant is otherwise subject to seizure for violation of the law. In this specific instance, there was no reason that this driver was subject to seizure. If you're going to stop a driver because that driver has a headlight out or that driver made an improper turn, then the proper mechanism is to ticket that driver and to keep going, not to ask a series of questions, conduct a web search, detain that defendant for a specific period of time, and then bring a dog out to do a dog sniff of the vehicle under Rodriguez. Secondly, with Rodriguez, it says an on-scene investigation into other crimes deters from the mission. And, probably as a policy argument, all of these things that are occurring with police stops and vehicles occurring, Rodriguez actually had a little bit of foresight into that and was concerned with the general interest of criminal law enforcement and the safety of the officers that stem from these traffic stops, and essentially seemed almost, not quite to chastise, but to suggest that officers need to make sure that they're not doing on-scene investigations of crimes and that they aren't stopping vehicles to investigate, but rather having valid reasons to stop them before they bring dogs out to sniff vehicles, because it can put them at risk for safety.
There was a valid reason to stop based upon the tail light or whatever.
On the headlight violation?
Yeah, whatever.
Well,
mean,
I can see that argument, yes.
It may seem trivial, yes,
Yes.
but there is a procedure for stopping and warning people that their lights are.
I agree with
So there's nothing nefarious about that.
Correct.
So the issue then, I think, you're suggesting that the fact that he had 15 air fresheners is not pertinent to the issue of whether the officer had grounds to bring a dog to sniff.
Yes, I think that that's part of the issue, but I don't think we can quite divorce that headlight issue from the fact that the officer actually itemized not just the headlight, but itemized other reasons that when he saw the headlight, he had noticed this defendant was familiar to him in some way and had described him as a black male. There was a lot of facts that were given right about the time he said he noticed that headlight. So,
And what was wrong with those facts, if they were true?
well, essentially pulling somebody over who you don't know who that person is, but you believe that that person might be a drug dealer, then that is a reason. He is basically essentially saying that I had a reasonable articulable suspicion that he was a drug dealer, and there was nothing in his activity or how he behaved that caused that. And because the officer wasn't able to find out any information, he then went searching for information because the driver did not act incorrectly to not just justify a ticket. So I think
He didn't say he didn't have any history, he did. So he didn't tell the officer about the 2006.
it was a traffic offense, Your Honor?
What, did he say, do you have any prior criminal?
Yes, I think he did. He said, "You have a prior prior record? And he said no, but it was a traffic offense. And so then that would mean most of us have prior records.
Offense it was.
I believe it was yes, because the officer testified, it was a traffic offense, and then there was some sort of indication that said like NC or something on it where it led the officer to believe that it was a traffic offense in connection with some sort of possession, but there was never a possession charge or anything found. So it was a traffic offense only that the officer found in searching. Do I have a minute to address?
Yeah, you have about 4 minutes.
Thank you. And so Judge Whitmore, and what your question was, I think that then shifts more to now the purpose for doing the dog sniff and in unnecessarily and unreasonably detaining the defendant to now not just pull him over, but now to detain him to do a criminal search, to then do an internet search when it's not found by when a record is not found by proper police officer means, and then to approach the defendant and start asking about, have you been smoking weed? The officer never testified he smelled any odor of unburnt weed or burnt weed, I guess I should say marijuana, or burnt marijuana in any way whatsoever, but he asked those questions, and then that was when he detained him to do the dog sniff, and then after that, they did an inventory search, which we also say was improper. So we're basically saying that based on State v. Anderson, as to the stop, and I do understand the court's perspective on that was a violation of the Fourth Amendment, but specifically as to the dog sniff under Rodriguez, I think the Rodriguez case outlines the U.S. Supreme Court's position on the dog sniff. The dog sniff, the contraband which was found was a fruit of the dog sniff, as after the dog had alerted the vehicle, then that's when the police officers searched the vehicle to find the contraband. And other than that dog sniff, they would not have been entitled to search the vehicle for a traffic stop on a headlight or an improper left turn, and that in detaining unreasonably that defendant for that dog sniff, that was where the contraband came from. So we're asking the court to reverse and remand to the trial court based on both of the issues, but more specifically under Rodriguez, the search with the dog sniff.
No, we have not read the transcript yet. We always do, but we don't always get everything before court, before arguments. So in the transcript, I know you weren't trial counsel, but you've reviewed it. And when we talked about the web search and so forth, I was going back and looking again at the trial court's order. And she indicated, now I don't know whether she's surmising that or whether that was the actual evidence that was presented, that it was actually him, the officer, I mean, when I say him, looking at different municipal court websites to see if he could find any information, additional information about this defendant, any prior convictions or whatever.
May I pull the
Anything
transcript?
about that in there?
I can pull the transcript really quickly.
No, that's okay, we can, I don't want to take more of your time, I'm just wondering if you recall that.
I don't recall specifically what he said he searched. I know that he did say a web search,
Right.
and I don't recall him. I think there was a question as to what else that entailed, and I think he said looking at different websites, to see if I can find
Let me ask you
information.
this, though, let's just assume for a minute that that's what did occur, that he looked at different municipal court websites. Do you have a problem with that? What's your position in regard to that? Instead of just looking at leads, he continues to look at different websites from different municipal court facilities or whatever.
Well, Your Honor, the issue with that is sometimes some of those websites are not accurate, and I do understand that in many cases, we can use a docket, and that docket can maybe show things that may or may not have been filed. It's not necessarily all-inclusive, and it's not always dispositive. And so there could be something, for example, I'm sure the Court of Appeals has seen cases where they may have escalated a charge or increased a charge of like domestic violence or something that enhances, and then come to find out that it was actually a dismissal or reverse from the Court of Appeals. So various things can happen on municipal court pages that you don't actually know the final disposition of the case. So to search those would be erroneous because the outcome may not be as the officer may perceive it to be, which is probably why it's
Well,
not.
I guess I was getting more into the aspect of the unreasonable delay. Is it reasonable to go beyond leads and to go to different municipal court websites and spend that additional time before you decide what you're going to do in regard to writing a ticket or whatever in regard to this traffic offense? In other words, I think we're going to have to make a determination what is reasonable amount of time as to to write the ticket for the minor misdemeanors. Because that's what we have to look at in regard to the drug dog coming to the scene. Because it cannot be unreasonable beyond the time that it takes to write the ticket. So that's what I'm getting at, I guess, because I've just not seen that before.
Well, and our argument is it is unreasonable to go further than the mechanisms in place for the police officers to be able to check records, and that does add to that delay for the dog sniff. And again, it would also be how many sites did we check and how long did that take? But if I'm remembering the case law correctly, I think it's, as you stated, that it's how long is reasonable to write a ticket to have them detained. So we believe that anything outside of the normal course of business for a police officer is additional and unreasonable under the Fourth Amendment.
Am I correct that the dog was in his car,
Yes, he's a canine officer.
in the car with Osaka?
Correct. And
I misunderstood, I apologize.
I believe the dog was with him, and what I'm unclear of is, I know he called a second cruiser, and I believe that he did the dog sniff upon the arrival of the second cruiser.
In the middle of writing the ticket?
In the middle of whatever he was doing, I don't believe that he was there by himself after he pulled over and immediately.
You waited till the second cruiser
Correct.
to do it, that's what I was getting confused over.
Yes.
Okay, so he waited for the second cruiser to arrive before he got.
That's my understanding.
Okay. All right, well, I appreciate that, thank you.
Okay, thank you.
All right, so we'll take the matter under advisement, issue a written opinion, and that will be sent to both sides, and you can also look on our website where we release the opinions. Thank you.